How does retaliatory eviction work in legal challenges? Imagine standing up for your rights as a tenant and then facing the threat of losing your home because of it. That's what retaliatory eviction is all about. It happens when a landlord tries to evict a tenant mainly because the tenant exercised a legal right. For example, if you complained about unsafe living conditions, asked for repairs, reported code violations, or joined a tenant organization, the landlord might see you as a problem. Legally, this kind of eviction is usually considered illegal because it's seen as punishment for standing up for your rights. In a legal challenge, the law often steps in to protect tenants from unfair eviction attempts motivated by retaliation. Usually, if an eviction happens within 6 months after a tenant takes a protected action, courts will assume it's retaliatory. The landlord then has to prove there was a legitimate reason for eviction that isn't related to the tenant's protected activity. For example, if a tenant reports mold or broken heating, and the landlord files eviction papers within that 6-month window, the court might see this as retaliation unless the landlord can show the eviction was because of unpaid rent or lease violations that have nothing to do with the complaint. Key parts of a legal challenge include showing that the tenant took a protected action like requesting repairs or reporting safety issues. The timing is very important because if the eviction happens soon after the tenant's action, it raises suspicion. The tenant then has the burden to prove that the eviction was retaliatory. The landlord can defend themselves by showing they had other valid reasons, like non-payment of rent or damage to the property, that are unrelated to the tenant's complaint. If a tenant believes they are being retaliated against, they can raise this as a defense in court. If the court agrees, the eviction can be dismissed, and the tenant might be awarded damages or reimbursement for moving costs and legal fees. Landlords often make mistakes by trying to evict tenants right after complaints without good cause or by not keeping proper records. These mistakes can make it easier for tenants to prove retaliation. Tenants should keep detailed records of all complaints, emails, and conversations with their landlord. This documentation can help show the timing and nature of their protected actions. It's also wise to respond quickly to any eviction notices and seek legal advice if they suspect retaliation. Landlords can still evict tenants if they have a valid reason that isn't related to retaliation, even within the 6-month window. For example, if the tenant violates the lease after making a complaint, the landlord can proceed with eviction based on that violation. Overall, laws against retaliatory eviction are there to prevent landlords from punishing tenants for asserting their rights. Both sides need to understand how timing and motives matter in these cases. Tenants should document everything, and landlords must ensure their eviction reasons are legitimate and well documented. Knowing these rules helps avoid wrongful evictions and keeps the process fair for everyone involved.